in addressing the question as to whether the non-joinder is curable by amendment, Council cited the case of Amina Hassan that has been referred to earlier in support of submissions that the non-joinder of the Deputy County Governor cannot be cured by way of amendment to the petition. He argued that such an action would be tantamount to introducing causes of action not pleaded in the present petition. Council averred that causes of action herein are governed by Article 87 of the Constitution and Section 76(1) of the Elections Petition Act, which bar the introduction of causes of action after 28 days have lapsed. Mr. Nyamodi submitted that this is not a mere technicality which can be cured by Article 159(2) of the Constitution of Kenya, and he relied on the case of Kithinji Kiragu versus Martin Nyaga Wambora to support his submissions. The petitioner respondent's case, the petitioner in their submissions addressed the petitioners in their submissions addressed the question whether the Deputy County Governor is a necessary party to the election petition and whether the non-joinder was fatal to the petition. Mr. Abubakar, learned counsel for the petitioners, submitted that the Deputy County Governor is a beneficiary of the Governor. He cited the case of Kithinji Kiragu, which has already been adverted to by Mr. Nyamodi, wherein the issue of non-compliance was raised in cross-examination. The court took the view that the proceedings concerned a validly elected party, and the Deputy County Governor is not such a validly elected party, but is a nominated party. Mr. Abubakar cited also the case of Dr. Thuoma Thenge versus Nderitu Gachagua, wherein the court held that the Constitution shall be interpreted in a manner that promoted the purposes of the Constitution. Article 87 of the Constitution intended the legislature to enact laws that would challenge elections. It was Council's submission that the Constitution shall be interpreted in a manner that promotes that rule of law, enhances human rights, as it's a human right to challenge elections. It was Council's submission that Article 181 and 182 of the Constitution are only triggered after the Governor legally assumes office via a properly conducted elections. He argued that the rights of a Deputy County Governor only accrue when the person who nominated him is a successful candidate in the election. Mr. Abubakar submitted that the instant petition is not against the Deputy Governor, and he cited Section 2, Section 13, Section 38, and 39 of the Elections Act, which do not make reference to the Deputy County Governor as a candidate in elections. He further argued that the declaration of the results at the polling station, tallying station, and the county do not involve the county governor. In addressing the issue as regards non-compliance with Rule 8.5 of the elections petitions rules, Council made reference to Article 159 2D of the Constitution, Section 80D of the Elections Act, and the overriding objectives of Rule 4 and 5 of the Elections, Parliamentary and County Elections Rules, and argued that the requirement under Rule 8.5 falls under the category of procedural technicalities and does not affect the substance of the petition. He argued that the petitions were not seeking to amend the petition to enjoin the Deputy County Governor, and that the petition is in order as it stands. Going through all these pleadings, the grounds, and the rebuttal thereto, in my mind, the views that arise, in my view, the issues that arise for determination are whether the failure to enjoin the Deputy County Governor is fatal to this petition. And secondly, whether the failure to comply with the provisions of Rule 8.5 of elections petition rules renders the petition incompetent. Indeed, challenge to an election wherein irregularities or illegalities are alleged is permitted in law. Such a challenge must, however, be prosecuted within strict guidelines and timetables. Failure to follow deadlines in election laws can be fatal and may invite an interlocutory application to dismiss. The Constitution of Kenya 2010 makes provision for electoral disputes other than the presidential election and the deadlines to be adhered to as regards filing. Article 87(2) reads, and I've set out what it says. The Election Act in Section 76(4) also provides, and I've set out what it provides, This section is interpreted to mean that the option to amend the petition was available before the expiry of the prescribed period for filing the petition, which is 28 days, which have already run out in this petition. Failure to comply is fatal to the petition, rendering it a nullity unless the court finds that the failure goes only to form. Time and other electoral proceedings, statutory requirements, are conditions precedent to instituting a proper electoral challenge, which are mandatory and peremptory. The election court cannot therefore extend time or allow amendments filed out of time unless the election legislation so provides. The question before this court in the instant petition is whether the deputy governor ought to be considered a successful candidate whose involvement in the instant petition is crucial. It's tried law that an omission to include a successful candidate renders a petition defective. In Abub Ali, Honorable Justice Kimaru stated, I have set out what Justice Kimaru said, and I've also set out what the court said in the Josiah Taraya Kipelian versus Olenkedienye case, both of 2013.
All right, so that